Day 3 of the Alex Murdaugh trial in Walterboro. Attorney Susan Williams gives me her analysis of this trial for this edition of Quintin's Close-Ups. And if you haven't already, subscribe to my YouTube channel and like Quintin's Close-Ups on Facebook.
Susan E. Williams, welcome back to Quintin's Close-Ups.
Thank you for having me back, Quintin. Good to be here.
Oh, you're very welcome. Needless to say, you are a criminal defense attorney and have many years of lawyer experience here in South Carolina and beyond. And I wanted to bring you back on Quintin's Close-Ups because obviously, as you know right now, we are in the opening statements right now of the Alex Murdaugh murder trial right down in Walterboro. Earlier today, 12 jurors were picked and 6 alternates that is, in the South Carolina murder trial of Alex Murdaugh. The 54-year-old Murdaugh, that is accused of killing his wife, Maggie, 52, and their youngest son, Paul, 22, at a family's rural hunting property down in Colleton County on June 7, 2021. Let me ask you this, Susan. What's the possibility when it comes to the demographics of these jurors?
The demographics of the pool that's there right now?
Yes, ma'am.
Well, I would hesitate to speak on the individual jurors because there is an order from Judge Newman prohibiting anything that would identify them by individually. But, juries in general are supposed to be a makeup of one's peers. They will be folks from Colleton County who are citizens, and there will be a panel of folks, 12 people, and I believe that he chose to have a number 6 alternate jurors in case they need to be used in place of the 12 that will be sitting. So, we can't really discuss too much about the individual makeup of the jury.
Now, from your attorney's experience, do you have a sense of the defense strategy or the state strategy with this trial?
Sure, yeah. So with every criminal trial, the burden is on the state, in this case, the Attorney General's office, to prove beyond a reasonable doubt that Alex Murdaugh is guilty of murder. And then also there are 2 counts of murder, and then there are 2 counts of possession of a weapon during the commission of a violent crime. So the burden is on the state to prove that Alex Murdaugh is guilty. And the defense strategy will be, if they even put up a case, which I'm assuming that they will, I'm pretty sure that they will, but some people may not know that they don't actually have to put up any case. They don't have to prove anything. A lot of folks believe that the defense has to prove that Mr. Murdaugh is innocent, and that simply is not the way the burden of proof works in General Sessions Court in South Carolina. So from the defense perspective, they will be wanting to take what the state has put forward and try to put reasonable doubt in the jurors' minds. They're going to try to chip away at the evidence that's presented by the prosecution, and that's how their entire strategy overall will be to put reasonable doubt in the minds of the jurors.
And Susan, going back to Monday when obviously the trial actually began, we all saw, Alex Murdaugh, come out of the, patrol car, for lack of a better word. And a lot of people saw him with a lot of SWAT team protection, for lack of a better word. Is that SWAT team protection standard for a defendant?
Sure. I guess it really depends on not every defendant necessarily, but the state has a duty to protect defendants. I was actually there on Monday, boots on the ground there in Walterboro. Yes, and I didn't see Mr. Murdaugh being transported, but the state has to protect the inmates that are part of that are being detained. So sure, they want to protect him and provide security. I noticed some heightened security as well, more security than what I'm used to seeing in the courthouse as well. And that's something that I understand the local police and the South Carolina Law Enforcement Division have been working on for quite some time. It looks like it's really amped up there, running smoothly. And, you know, as someone who's in the courthouse in and out a lot, it's really, I really appreciate the folks who protect everyone's safety there, because it is such an important part and something that we can never take for granted.
Yes, ma'am. And let me go back to Monday. Obviously, the big talk was obviously about the witnesses. From my understanding, they have named over 250 people as potential witnesses to testify. Does this defense only list, as many people think that it is, does that actually concern you as a lawyer?
It doesn't concern me at all. You know, like I said earlier, the defense doesn't have to prove any part of their case. So the defense list they may not, you know, just because these folks are listed by the prosecution or the defense, it doesn't mean that they're actually going to call these people. One purpose of that witness list is to so that the jurors can know these names and say, you know, to whoever it is asking what they, if they know these folks or whatever. And again, I'm not trying to talk about jurors individually,
Right.
but it doesn't have to be equal. Like, it doesn't have to be, well, the state has 100, so the defense has to have 100 witnesses. That's not really like the scales of justice there. I would expect the state to have a lot more witnesses, because the burden of proof is on the state, and the burden of proof is not on the defense. So, you know, I did see that witness list, and that was a very interesting list that I knew some of the names on there, some of them I didn't, but I'm really looking forward to seeing what kind of evidence is presented, because I've been waiting for this for quite some time, and I'm sure that the victims' family and friends and loved ones have been as well. So I hope that they get the answers that they've been waiting for patiently all this time.
And speaking of the witness list, isn't it odd to you, Susan, that Fleming isn't on either of the lists?
Well, that actually presents a pretty interesting point, because Fleming would have more to do, as I understand it, with the allegations of white-collar crime that Mr. Murdaugh is accused of. I don't know if I haven't heard that Mr. Fleming has any place as a witness for the double murders. But again, I don't know what kind of evidence will be presented. But yeah, I hadn't thought of that. That is interesting. Yeah.
Yes, ma'am. And that's obviously Beaufort County Attorney Corey Fleming, by the way. But let me ask you this too. I know that I was wondering this too, Susan. If 250 is just to do as much as possible to affect the jury pool in a small town that really everybody knows, is that what you're looking at right now?
Can you repeat the question? I didn't quite understand what you said. I'm sorry.
Oh, yes, no worries. And I wonder if the 250 is just to throw in as many possibles as possible to actually affect the jury pool in a small town that everybody actually knows.
Are you asking if 250 people is a lot for the jury pool?
Yeah, that too. Yes, ma'am.
I think that they needed to get a pretty good number of folks here, more than usual. My understanding is that originally it was over 900 before some folks, you know, there are some things that happen prior to that get the numbers dwindled down. But, you know, it is such a very small county as far as population-wise. It's a very close-knit county. And I think that they needed a lot more jurors in the pool because of the high-profile nature of this trial and of this case, and all the cases that are surrounding just this case. This is, as you know, 4 indictments of well over 90 indictments, other indictments.
Well, that brings me to my next question. When exactly do you anticipate Alex Murdaugh to be tried for Gloria Satterfield and Stephen Smith?
As far as a trial, so my understanding is that Gloria Satterfield, he has that Mr. Murdaugh has settled with attorney Eric Bland. I may be wrong on that, but I thought that they had settled their civil suit. So I don't know that there are any pending criminal charges with Miss Satterfield. As far as I don't know exactly what is pending there, but for Stephen Smith, I believe that Stephen Smith is. There are no charges with Mr. Murdaugh with Stephen Smith, so I wouldn't expect anything to come of that unless new charges come about. I haven't heard anything about any charges with Stephen Smith.
And I know over the weekend I actually saw this and actually tweeted it out as a news story on Twitter, but Judge Clifton Newman has ordered representatives of Snapchat and Google, according to WCBD, to appear as material witnesses in the murder trial for obviously former attorney Alex Murdaugh, who is accused of fatally shooting his wife Margaret and the youngest son Paul. What does that tell you?
Well, there are certain rules that lawyers have to go by to get social media posts to discuss those or to enter those into evidence if there is something to enter into evidence. And so because of the rules of evidence, there's a lot of rules that attorneys have to follow in order to get some things admitted at trial, depending on what they're trying to get admitted. So the records custodian is a way to help try to get information into the trial admitted so that it can be presented to a jury. It seems like from looking at TV shows and things like that you can just sort of bring your phone in and this is what's on Snapchat. And unfortunately, it's just not quite that easy. You have to get these things authenticated. And there's a lot of sort of red tape there's a lot of work behind just bringing in social media posts. And you have to follow the rules to do that, and Judge Newman signed an order, I believe, to allow someone to come and testify about something that's going to be presented about Snapchat. I'll be looking forward to seeing what that is.
Yes, a lot of people on Twitter basically asking what is exactly on that video on Snapchat, so we'll see what happens with that.
Yes.
And Susan, this might be a weird question or irrelevant question, but what else do you see the state wanting to admit, and what else do you see the defense trying to, obviously admit in this trial?
Well, we know that the state is wanting to get into prior bad acts that are allegations of things that Mr. Murdaugh has been accused of doing. And again, he's not been convicted,
right?
But he's accused of some things,
right?
And the state's made a motion to have those things admitted, and the defense, of course, does not want these things admitted. Those same rules of evidence that I was just talking about can cause a lot of hurdles in trying to get evidence admitted, the rules of evidence. So under the rules of evidence, I don't know. I don't think that Judge Newman has, I don't know. Things have sort of progressed throughout the day today, and I haven't been able to watch the trial every minute of it. The last time I looked, they were doing opening statements. I don't know if he's ruled on that motion, but that was one motion that I expected the state wanted to have granted, and the defense wanted to keep those prior bad acts out from what the jury hears.
And I know, according to Katie Soap with Channel 4, Buster Murdaugh is actually seated 2 rows behind his father right there in Colleton County, and other members of the Murdaugh family are also in court. So what does that tell you?
Well, if they're sitting behind Alex Murdaugh, then typically when you go into a courtroom, you have 2 sides of a courtroom. One side is for the prosecution, and one side is for the defense. And so you have to sit on one side or the other. And if they're sitting behind Mr. Murdaugh, it appears that they are supporting their brother and their father. So I guess they're there for that. They may be there because they're under subpoena. I believe that they were also, on that witness list. So if it ends up that the witnesses end up being sequestered, then they will not necessarily, they won't be able to sit in on the trial before their testimony if they testify. But if the witnesses aren't sequestered, then they can sit there and watch the entire trial. Opening statements are not considered evidence. So if they are there for that, then that would explain why they're sitting there today.
And one last question for you, Susan. Will this trial end up in an acquittal or a hung jury?
Quintin, that is the question that we all want to know the answer to. If there is not a 12 panel, if there's not a unanimous decision of the jury, if they all 12 can't agree, all 12 of them, it can't be 1, 2, 3, or undecided. It has to be all 12. It's not a majority. It's every single one of them. They all have to decide on the same exact verdict. If they can't, then it could be a mistrial. So that would be the answer for the mistrial, is if they're deadlocked. They can't come to a decision. And of course, if all 12 of them believe that he is not guilty on all 4 charges, then that will result in a not guilty verdict.
Wow.
That's how you have an acquittal or not guilty. Of course, if he was found guilty, then all 12 would have to agree that he's guilty on each indictment. There may be a different decision for each indictment. We don't know.
Wow. Well, criminal justice attorney Susan E. Williams, thank you so much for your time. And again, welcome back to Quintin's Close-Ups.
Quintin, thank you so much for having me.
Oh, you're very welcome anytime.